If you're over 55 and you own a firearm for self-defense, there's something you need to understand right away. Self-defense law is not simple. It's not one size fits all, and it absolutely is not the same in every state. A lot of online content makes bold claims about hidden protections or automatic legal shields. The truth? Self-defense law is nuanced, highly fact-specific, and depends heavily on jurisdiction. Today, we're going to break this down responsibly, not with myths, not with viral sound bites, but with clear principles that actually matter if you're a senior gun owner. And before we go any further, this is educational information, not legal advice. Laws vary widely by state, and if you ever face a real legal issue, you must consult a qualified attorney in your jurisdiction. Let's start with something foundational. 1. Self-defense is about reasonableness, not age alone. At the heart of every self-defense case is one core question: was the use of force reasonable under the circumstances? In most states, juries are instructed to consider what a reasonable person would have believed in that situation. Now here's what matters for seniors. Courts often allow juries to consider the totality of circumstances, which can include age, physical condition, relative size differences, prior threats, medical limitations. That doesn't mean age gives someone automatic legal protection, but it does mean context matters. If you're 72 and someone significantly younger and stronger assaults you, that context can influence how a jury evaluates perceived threat. The key takeaway: self-defense law evaluates the entire situation, not just the final action. 2. Castle Doctrine and stand your ground, what they actually mean. You've probably heard these terms: Castle Doctrine, stand your ground. Let's clarify them carefully. Castle Doctrine. In many states, Castle Doctrine means you generally do not have a duty to retreat inside your own home before using lawful defensive force. However, it does not give permission to use force in every situation. The threat must still meet legal standards: imminent danger, unlawful entry, etc. Stand your ground. Some states extend the no duty to retreat principle to places you are lawfully present. But again, the force must still be legally justified. There is no blanket immunity, and laws differ significantly from state to state. If you are over 55, it's especially important to understand whether your state has stand your ground, whether it imposes a duty to retreat. What the exact statutory language says, never assume based on YouTube commentary alone. 3. Medical conditions and physical limitations for seniors, health matters. In court, a defense attorney may present evidence about mobility limitations, arthritis, cardiac conditions, fall risk, reduced reaction time. But here's the important distinction. These factors do not create automatic rights. They provide context. Documentation matters: medical records, doctor statements, prescription compliance. If physical vulnerability is relevant in a case, having clear documentation strengthens credibility. 4. Prescription medication and legal responsibility. Many seniors take prescription medications. If a self-defense case arises, prosecutors may explore whether the medication impaired judgment. The medication was misused. There was intoxication involved. The safest approach is simple: take medication only as prescribed. Do not mix prescriptions with alcohol. Maintain updated medical records. Keep pharmacy documentation. Courts distinguish between lawful prescribed use and reckless misuse. Responsible compliance strengthens credibility. 5. The real risk. What happens after a defensive shooting? One of the biggest misconceptions is that a clear self-defense case means no investigation. In reality, almost every defensive firearm discharge will involve police questioning, evidence collection, possible arrest, prosecutor review, grand jury review. In some states, even if no charges are filed, the process is stressful and complex. Seniors should understand. You have the right to remain silent. You have the right to an attorney. You should avoid making speculative statements. You should not discuss details casually at the scene. Always request counsel before giving a full statement. 6. Jury perception and credibility. Age can influence perception, positively or negatively. Some jurors may view seniors as more stable, less impulsive, less likely to fabricate. Others may question reaction time, judgment under stress. Cognitive clarity. What matters most is consistency. Inconsistent statements damage credibility at any age. Clear documentation, lawful conduct history, and responsible firearm ownership habits help establish reliability long before a courtroom is involved. 7. Criminal records and firearm eligibility. Many seniors have decades-old records. Important facts. Federal law prohibits firearm possession for certain felony convictions. Some misdemeanor domestic violence convictions also trigger federal prohibitions. Expungement laws vary widely by state. Expungement does not always restore federal firearm rights. Before assuming eligibility, consult a qualified firearms attorney. Verify state and federal impact. Do not rely on online summaries. The consequences of unlawful possession can be severe. 8. Mandatory minimum sentencing. Reality check. Mandatory minimum laws vary by jurisdiction and offense type. Some states allow judicial discretion under limited circumstances. Others do not. But here's the truth. Avoiding conviction is far more important than relying on sentencing mitigation. The best protection is avoid escalation, avoid brandishing, avoid unnecessary confrontation, avoid teaching someone a lesson. Self-defense is about stopping a threat, not punishing someone. 9. What seniors should focus on instead. If you are over 55 and own a firearm, your priorities should be 1. Training, defensive firearm training, de-escalation training, scenario-based instruction, use of force law education. 2. Secure storage, quick access safes, biometric lockboxes, separation from grandchildren or visitors. 3. Legal education. Take a state-specific concealed carry class. Review statutes annually. Consult a local attorney. 4. Health awareness. Know your reaction limits, understand your mobility, plan defensive strategies around your physical reality. 5. De-escalation. The safest fight is the one avoided. Distance, verbal boundaries, exit routes, calling authorities early. Firearms are last resort tools. 10. The psychological reality of defensive force. Even a legally justified shooting can result in PTSD, depression, community backlash, civil lawsuits, media attention. Seniors should plan for emotional aftermath, legal expenses, support networks, counseling resources. Self-defense is not just a legal event, it's a life event. 11. Civil liability, the part nobody talks about. Even if criminal charges are dismissed, civil lawsuits may follow. The standard of proof in civil court is lower than in criminal court. That means you could be cleared criminally and still face financial exposure. Insurance options exist in some markets that cover legal defense costs, civil damages, policy dependent, attorney retainers. Research carefully. Read fine print. Avoid marketing hype. 12. Laws change. Frequently, court decisions reshape. Stand your ground application. Use of force standards. Burden-shifting rules. Jury instructions. Legislatures revise statutes regularly. What was true 5 years ago may not be true today. Stay informed through state legislative websites, reputable legal organizations, local attorneys, verified legal education sources. Final thoughts. If you're over 55 and you own a firearm for self-defense, the most powerful protection you have is not a hidden statute. It's education, restraint, documentation, professional legal advice, responsible conduct. There are no magic shields in self-defense law. There is only preparation, discipline, and understanding how the law applies in your specific state.